first and foremost, there's been no material change in circumstances to warrant a reduction in bond.
Thank you. So, Mr. Nips, when I reviewed the court file, I saw that there was it was scheduled for a pretrial detention hearing. The state at that time did not pursue pretrial detention, so it turned into a bond hearing. And that was with Judge Ketchel on September 5th, 2024. He was the assigned judge at the time. So this bond was not set by a different judge at first appearance. It was set by the judge that was assigned to the case at the time during a bond hearing. And I'm not able to discern from anything I've heard today that there's been any material change in the circumstances since Judge Ketchel evaluated the case and set the bond. Has there been any change? Has there been any change in the situation?
Judge, other than he's turned 18 now, but he's been in jail for quite some time, I think that's important.
Well,
I can't represent to you that there's been any substantial change.
I understand.
It's been there a while.
Thank you.
Judge, a colleague was just pointing out to me that, it was, the bond hearing was more like an extended first appearance. There was really not a chance to say a whole lot of anything. We've had such circumstances, but again, if he hadn't been sitting in jail now since August of last year, he's almost a year sitting in jail.
I understand. The case does involve a death, and it was the judge assigned to the case who set the bond. So in light of that, now if it had been just a different judge at first appearance, not the assigned judge, then I would have authority to reevaluate because I'm the judge assigned to the case now, but it was the assigned judge who set this bond. So without some change in circumstances, then I wouldn't find grounds to modify it. So with respect, the motion is denied, and the state's going to make an offer, from what I heard Ms. Sandler say, sometime soon.
There's been nothing formal, but there's a lot of discussion.
Okay.
The state anticipates formalizing an offer later on today, actually. I spoke to my supervision.
Okay.
Thank you.
Thank you. Thank you.
And Your Honor, that concludes my business. May we excuse?
Yes, thank you. Do we have minutes from this case? Okay. Mr. Flowers? Oh, I don't see Mr. Flowers. Okay, and is Mr. Shaw present? I don't see him. Okay, Ms. Merrifield?
Morning, Your Honor.
Good morning.
Judge, if I could address one case that was still showing on the docket. It was Tyler Otten in 25 CF 1004 for a bond hearing. We did file a notice of cancellation on the 9th. For whatever reason, the e-portal hasn't been our friend lately, so I don't know if you have had an opportunity to see that. But that has been canceled. We have already addressed the bond issue for Mr. Otten.
Okay, thank you for telling me that. The e-portal has had some issues.
Yes, ma'am.
And also the clerk's office switched their system. So those two things, there has been a little bit of
Yes,
a
ma'am.
delay in getting things So I will just go ahead and cross that one off. Thank you for that.
Thank you, Judge. And I'd like to call Randall Booker at 23 CF 1346. Mr. Booker is present and approaching.
Ma'am, as Mr. Booker approaches and gets settled with Ms. Merrifield, excuse me, the victim in this case is not present, but she is in agreement with the sentence. And a close friend of hers has provided a statement on her behalf that she just wishes to be part of the court record. We don't need to necessarily read it in there. Correct with that?
Yes, of course.
I have provided a copy to Ms. Merrifield, and she is aware of it.
Okay.
We
So-
have received it and have no issue with it being admitted into the file.
Okay, so it doesn't need to be read, it just needs to be put in the record.
Yes, ma'am.
Okay, thank you. I'm going to write the case number on it, just so that
I'm
it's...
sorry, I should have included that.
No problem.
Do you have
This-
the number, ma'am?
23 CF 1346?
Yes, ma'am.
All right.
And Judge, we have reached an agreement in Mr. Booker's case, if I may approach.
Yes. Thank you so much.
And Mr. Booker in 23 CF 1346 would like to withdraw his previously entered not guilty plea, enter a no contest plea. It is to an amended charge. I have listed the proper citing authority for the clerk's benefit and the terms and conditions listed in the signed plea agreement.
All right, could the defendant and the attorneys approach, and I'll go over part of this at the bench.
Thank you, Judge.
Sure.
We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999.
West Florida for over 30.
And need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Thank you, Ms. Merrifield, and thank you, Ms. Basso.
Thank you, Judge.
And I think
For
you have
more
one more
than
on the
70
docket.
years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated.
And approaching.
Yes, thank you.
And Judge, we have reached an agreement in Mr. Hoskins' case, if I may approach.
Yes,
She's behind, Judge.
thank you so much.
And Mr. Hoskins, in 23 CF 2425, is withdrawing his previously entered not guilty plea. He is entering a no contest plea. This is to a lesser included offense that is articulated on the plea agreement to include the statute for the terms and conditions outlined in the plea agreement. And I do want to make note, this particular case, Mr. Hoskins does not reside in this state, so I have already provided information to probation. He will be subject to the cost associated with interstate compact, and he has been made aware.
Great, thank you. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just state your name.
I'm Ladarius DeJuan Hoskins.
Thank you. Sir, in case 23 CF 2425, have you had a chance to talk to your lawyer about the original charge in that case and also the lesser included offense of felony battery that it looks like you're entering an agreement to plead to?
Yes, ma'am.
All right. Did you read and sign the plea agreement?
Yes, ma'am.
Is this your signature on the last page?
Yes, ma'am.
All right. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to have a trial in this case?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing in your agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I have a score sheet. It shows 37.4 total sentence points. Any objections or corrections?
No objection from the defense.
All right. Is there any exculpatory DNA?
None known by the defense.
No, Your Honor.
Okay. And I do find a sufficient factual basis based on the arrest report. Has the state discussed the agreement with the victim?
Yes, Your Honor, the state has discussed this with the victim.
Okay, thank you. Sir, if you're not a U.S. citizen, do you understand the plea could subject you to deportation?
Yes, ma'am.
All right. And how do you plead to the lesser included offense of felony battery, which is a third-degree felony?
No contest.
I accept your plea. I find it was freely and voluntarily entered. According to your plea agreement, the statute is 784.041, subsection 1. That's the statute for the offense you just pled to. In accordance with your agreement, adjudication of guilt on that lesser included offense is withheld, and you were placed on probation for a period of 48 months. There is a $40 cost of supervision. Now, that applies in Florida. I have no idea what it would be if you're able to transfer to Alabama. It might be a different amount. I don't know. There's a transfer fee also included in that. And while you're in Florida, there's a 4% surcharge. I just don't know what the cost of supervision in Alabama would be. Let me check on the court costs. Is it 870?
867.
867 in court costs. It says on your plea agreement 870, but it's 867.
Yes, ma'am.
You must perform 100 hours of community service work, which may be bought out at the statutory rate. You must complete an anger management evaluation and any recommended treatment. You may have no contact whatsoever with Samantha White. It says on your plea agreement that you live out of state and that you may transfer to Alabama, assuming you go through that process and pay the cost associated with the transfer. So in light of that, I need to make you aware, you must check in here with Florida. You cannot go to Alabama until Florida and Alabama work it out and you get the green light to go from Florida. If you go to Alabama without getting permission from Florida first, that's a violation, okay?
Yes, ma'am.
All right, so you have to get approval before you can go to Alabama. Did I leave off any terms or conditions or anything about the plea?
Nothing that the defense saw, Judge.
All right, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Please check in with probation here in the courtroom before you leave, and then when you leave the courthouse, go straight to probation to check in their office.
Yes,
Okay?
ma'am. Thank you, Your Honor.
Thank you. Good luck to
That's
you.
all I have this morning.
Thank you.
Can I follow up on something because it may affect our constitution court basis that he has to stay here pending the transfer? It's my understanding if he's a legal resident, he can provide proof of that he's allowed to travel back pending the transfer, so I wanted to clarify that.
With travel paperwork from probation, yes.
As long as probation says it's okay for him to go, he can go. What I'm worried about is somebody that goes without getting permission from Florida local probation first.
That's why I want to clarify on that, Robert, because it's a different story if you're a legal resident versus here and they want to transfer out.
Oh, okay. Well, as long as, all I'm saying is, don't go to Alabama until probation here says you can.
Yes, ma'am.
Okay?
Yes, ma'am.
Thank you.
Thank you, Judge.
Sure. Mr. Flowers?
Your Honor, good morning.
Good morning.
I'm not mistaken, Kristen Hawkins is the case that's listed. That's all I had. Is there another one that the court is looking at?
I have a few. I have Ms. Hawkins, and
Ms.
then I
Hawkins
have
is
some
good.
other ones. All right, and this is case 24 CF 222, and Ms. Hawkins is present.
Your Honor, we had the state has made an offer, that a good offer. We've been through it with Ms. Hawkins for a long time yesterday. Candidly, this is an incredibly emotional time for Ms. Hawkins, and it may very well be that this case will dispose of itself consistent with that. Judge, we're not comfortable executing the PTI agreement that's been tendered to us at this time for some reasons consistent with the situation we find ourselves in, the finality of it all. We're asking for a date certain that we can come back and deal with this. Perhaps a continuance would be the most appropriate way to do it, but it's a difficult time. It's an unusual circumstance. The state couldn't have been more magnanimous. They've done a great job in negotiating back and forth. That's not our problem. Frankly, it's an unusual case, Your Honor, with some unusual circumstances. Would that be fair? Would you agree with that assessment, ma'am? So we're asking that it be continued. Yeah, and Your Honor, Mr. Shaw points out accurately that something that I didn't tell the court, that it was set for a plea or continue today, if we're not mistaken.
I'm not sure it was set for plea or continue. And I'm just looking through.
Your Honor?
Yes.
Yesterday, when we discussed putting it on for today, the state did ask if it was for plea or continue, and Your Honor did confirm, just for the purposes of subpoenas being sent out this late.
Okay. Yes, I have it down today for a plea. So I know that I had previously said last continuance, that was on April 21st, that was to June 9th. And then on June 9th, we put it on yesterday's docket, and then yesterday we put it on today's docket. So
yes,
what are we looking at as far as, this case is a year and a half old. So what are we looking at for time frame?
Judge Tim Shaw for Ms. Hawkins as well. I would like to, and I know we had a long discussion yesterday about the September trial date. I think we put it on the August, as an August pretrial for September 2nd or so, if the dates stick in my head. I know we've got another case going to trial. This one isn't particularly complicated. It's like Mr. Flower said, it's emotional for our client, but it's not a particularly complicated case. I think it can be tried in a day.
I agree.
And so I think we can try it on that September week as well.
Okay.
This wouldn't be one that I'd need to have a whole month getting ready for.
Gotcha. I also have the week of August 25th as a trial week. Now, Mr. Patel was not available that week, which affected some of the other cases that we talked about yesterday, but I don't believe Mr. Patel is involved in this particular case, correct?
No. Correct. And if you might me look at my
Go right
calendar.
ahead.
You said August 25th week?
August 25th. So the other cases that we talked about that Mr. Patel is co-counsel on, we had talked about September 2nd on those because he's not available the week of August 25th.
My calendar appears open on the first 3 days of that week. So.
We're good.
Okay, so here's what we will do. Does the state, do you object to a
No,
continuance?
Your Honor, the state doesn't object, and the state will be ready for trial the first week.
All right, I'm continuing the case to pretrial on August 11th, and this will be the last continuance. And we will plan on trying the case during the week of August 25th, okay?
Thank you, Your Honor.
Sure. So August 11th, 9 o'clock, ma'am, stay in touch with your attorneys, okay? And if y'all need to bring it in early for a resolution, if you reach a resolution, then I will always accommodate an early plea. I'll find you time.
Thank you.
Okay?
Thank you, Judge.
Thank you. Thank you.
Judge, the other matter you may have seen under my name was Damron, D-A-M-R-O-N.
Yes.
That motion has been withdrawn. Your Honor, that case has been disposed of.
That's why I was wondering why it was on the docket, but I'm glad to hear that it's resolved.
It is resolved. Thank you.
Yes, thank you. And let me make sure there's no other ones. I think I might have had, let me see, Mr. Shaw might have had another one.
J.D. Bartley, Your Honor. It's VOP.
Yes, I do have that one.
And Judge, if we may need to pass him until you finish up the docket, if we're going to have, and quite frankly, I hadn't seen him here yet. I talked to him yesterday and again this morning, so
Okay.
he told me he was here, so.
Okay, well, I'll go ahead and take the other cases, other private attorneys, and we'll see where we stand.
Thank you.
Sure.
Thank you, Your Honor.
Thank you, Mr. Flowers. Mr. Rare? I know I just saw Mr. Rare a minute ago. And I don't see Ms. Dudley. Oh, okay. All right, I think I have run out of people on my list, but I see other private attorneys present.
Your Honor, I have a brief matter that I could address before the court.
Yes, Mr. Harsher, correct?
Yes, Your Honor. Thank you for remembering. Covering a matter for Attorney Tony Henderson this morning, Judge. This is Martin Ariano Jr., 22 CF 2884. There was a motion to terminate probation. I believe Mr. Ariano, almost 2 years to the day, entered a no contest plea to counts 1, 2, and 3. He has maintained abiding by every circumstance of the plea agreement. And I believe there's been stated that there was no objection by the state attorney to terminate his probation.
All right, and the state, what's your position?
Your Honor, the state did reach out to the victim. We spoke about it 2 different times. He has no objection to this defendant probation being terminated early. The state has no objection. I did not see any violations or anything like that when I reviewed the record.
I reviewed the record as well, and I am granting the motion. Sir, you've done everything that's been asked of you. You haven't had any violations. Thank you for your compliance with probation. Thank you for taking probation so seriously. And I'm terminating your probation, sir.
Thank you, ma'am.
Thank you. I'm entering an order now.
Thank you, Your Honor.
Thank you.
Thank you. I believe that's all I have. May I be excused?
Yes, thank you so much. All right, Mr. Rare.
Thank you, Your Honor.
Thank you.
Your Honor, I've got 2 on the docket this morning, both of the same issue, motions to withdraw. The first is Mercedes NSCAT with an E, 24 CF 2101. Notice of today's hearing provided since May to Ms. NSCAT. I've not heard any response from her as provided to her last known email and last known address. We are still looking to withdraw.
All right. Mercedes NSCAT, are you present? Okay, I do not see the defendant present in the courtroom. I checked. I did see that you sent the motion I'm looking to see if notice of the hearing was sent to the defendant. Actually,
And I know from our office, my notes show that we sent that on May 22nd,
okay,
both by mail and by email.
great. The certificate of service just stated it was by email on the motion. And then on the notice of hearing, it just said it was provided to the state. So I just wanted to make sure
Correct.
you
And
sent.
I can certify to the court that we didn't, that's a typo on our end, and we sent it to the state, but we also sent email and physical mail to the client's last name and address.
Okay. And what's the state's position?
Your Honor, the state is requesting a no bond habeas.
Okay. Is there a waiver on file? There is.
There had been a standing waiver on file. If the court grants, obviously I don't any no longer represent Ms. Inscap, I would ask the court to set a new date for her, issuing you notice to her, and then if the state wants to proceed, if she does not appear that date, I'd ask for that.
Yeah. Because it's a motion to withdraw and there's not an order requiring her presence, I'm not going to issue a capias at this time. I will grant the motion to withdraw to the public defender's office. I don't see an application in the court file. This is Miss Mercedes Inscat, case number 24 CF 2101. So 2101. Let me look at the first appearance paperwork. It looks like the PD's office was appointed at first appearance, but then shortly thereafter, oh, and it looks like Ms. Farkas did file a notice of appearance, and then about a month later is when Mr. Lupella and Mr. Rare filed their notice of appearance, so the PD's office was relieved. So what I will do in light of that is reappoint the Office of the Public Defender.
Yes, Your Honor, it's going to be Ms. Farkas, and what I was asked is the court do a provisional appointment pending the application.
The court will do so. Provisionally appointed, pending her, the defendant's filling out the form and the clerk reviewing it and finding that she's indigent.
And what is that court date for Ms. Farkas, Your Honor?
That would be August 11th. For pretrial, let me see if the defendant is out on a surety bond. Yes, there is a surety bond. There's a bail bondsman. And the defendant, despite the fact that there is a waiver on file, the defendant's presence is going to be required on August 11th, because now that private counsel has withdrawn, I need her to fill out that form to make sure she can be represented by the public defender's office. So you send notice to the bondsman, right? Okay, great. The bondsman will be notified, and Ms. Farkas, I know it's been a year since you were appointed on this case and then were relieved, so I don't know what contact you will be able to achieve. Yes.
Thank you.
But I'll just put down defendant's presence is required. And Mr. Rear, could you please send me an order granting your motion to withdraw?
I do, Judge. I've got a hard copy, or if the court prefers, I can send a digital copy later.
Does it appoint the PD?
It does not. I can add that in and send it to the court's office.
Would you mind, please just send it electronically that today we had a hearing on your motion, the defendant was not present. I granted your motion and I provisionally appointed the PD, and please put her next court date in there.
I can, Judge.
Thank you. This is August 11th at 9 o'clock for pretrial. and her presence is required at that hearing.
And that concludes that case, Judge. And the other I have is Powell Harna. It's John Doe, a.k.a. Powell Harna. He's co-defendant and spouse of Ms. Inscat, and that is the exact same motion to withdraw issue, same address.
Okay, and that's 24 CF 2087.
Correct.
And was notice of the hearing and a copy of the motion provided to the defendant?
It was, Judge. We have the same last known address for the two of them and the same two emails they provided to all of them.
Okay. Is his name Pavel Harna or Harna Pavel?
Powell Harna.
Pavel Harna. Pavel Harna, are you present? He is not present. I'm just looking at the file. And there is a bondsman. It does not look like the public defender's office was appointed at first appearance. All right, I am granting your motion. I am still going to provisionally appoint the office of the public defender pending Mr. Harna's filling out the application and getting approved, and I know there's probably going to be a conflict.
Yeah, sure, I was going to address that there will likely be a conflict, so I don't know if the court, how we resolve that early this week. But given, I think we had this issue come early this week, and I'll let the court have the order specified for Mr. Nutt stating that
There's a conflict.
the court addressed the conflict, and so the order would reflect the PDs that appointed the conflict was addressed in court, and so the court will be appointing the RCC to that case.
I will do so. I will find that that Mr. Harna is a co-defendant of the previous case, Ms. Inscat, and that creates a conflict with the PD's office representing both of them, so I'll go ahead and find there is a conflict. And I'm appointing Mr. Harper, Office of Regional Conflict Counsel, to represent Pavel Harna, a.k.a. John Doe, in 24 CF 2087. This is a provisional appointment pending Mr. Harna's completion of the application and approval or determination by the clerk that he is in fact indigent. And Mr. Harper is present. And Mr. Rare, if you could put all of that in your order that I... Thank you. I found the conflict with PD, so I'm appointing regional conflict provisionally pending Mr. Harna's completion of the application. I will set Mr. Harna for August 11th at 9 o'clock for pretrial. He needs to be present that day. Despite any waiver that may have been filed, I need him present so that he can meet with Mr. Harper if he hasn't done so prior to then, and he can fill out the application to make sure that he qualifies for court-appointed counsel. I do see there is a bondsman, so the bondsman will be notified. Is there anything else I need to address on either of these cases?
I don't believe so, Judge. I'll try to get you those orders by end of day today.
Fantastic. Thank you very, very much.
Thank you, Judge.
All right. Anything else on the docket for you? I don't think so, Mr. Rare, but I'm just checking.
I don't believe so, Judge.
Okay.
Just the two today.
We have one, it was at 1:30 though.
Yeah, I'll be back at 1:30.
Great.
Thank you, Your Honor.
Yes. Who is that? Somewhere. Oh, I've got it right here. Is it that one right there? Okay. There is an inmate I need to call at this time because he's needed in another courtroom, and he does not have an attorney. This is Luke Kimsey, Kimsey, case number 23 CF 1671. Good morning, sir.
Morning, ma'am.
I'm Judge Clark. Can you tell me your name?
Luke Aaron Kimsey.
Thank you, sir. You're here on allegations that you violated your probation. I saw that you don't have an attorney presently representing you. Sir, would you like me to appoint a lawyer for you?
I believe it was supposed to have been Austin David.
Oh, okay, that's in your other case. I think you have another case that you also have court on today, 25 MM 1776. I'm here on case 23 CF 1671, and I don't show that you have an attorney in that case, but
Your Honor,
Mr.
Good morning, Mr. Kinsey. I spoke with the state about this case. Mr. Kinsey made one that asked, inquire about the state's offer in this case. I think that'll probably resolve that and his misdemeanor as well today.
Okay.
Would you like to hear the officer?
And sir, you do not have to respond in any way. You're being recorded. This whole table is full of prosecuting attorneys, so anything you say could be used against you. I'm just asking you to listen right now, and she's going to tell you what the offer is,
Yes, ma'am.
okay? I just want you to be aware anything you say could be used against you.
Duly noted.
In case number 23CF1671, the state is offering to admit the violation of probation, credit for time served in the Okaloosa County Jail, $100 cost of prosecution, 90 days to pay any outstanding monetary obligations before going to a civil lien, and then revoke and terminate probation. And then in 25MM 1776, it would be adjudication of guilt, Okaloosa County Jail, credit for time served, and $270 in court costs.
Sir, do you need some time to consider?
No, I can
Okay.
go ahead and take care of that one.
All right.
Your Honor, I have a plea agreement drafted.
Oh, great. Okay, thank you. They have that in writing for you.
Okay.
So I want you to read it.
Read it.
Yes.
Yes, ma'am.
Read it, and if there are any questions about it, then
Okay. So that would be pretty much no more probation. And then I get out today.
You should get it.
Okay.
So just read that over the
Yes, ma'am. Okay. Okay. All right. Thank you.
Your Honor, just for the record, it sounds we're reporting to the misdemeanor case. Can we withdraw based upon the agreement reached with the state and Mr. Kinsey on the misdemeanor case?
sir,
Save him $100 or so.
yeah, sir, do you have any objection to the public defenders if
No, ma'am.
withdrawing, if you're going to enter that agreement? The reason they're asking is that would save you some money.
Yeah, no, that's perfectly fine.
Yeah, sure. Thank you.
Okay.
Once you read that over and you're ready, just sign here and date here, and then just check that. Okay?
Yes, ma'am. Thank you.
Thank you.
It's a nice pen. Do I need to date it?
Yes.
All right. Thank you.
Your Honor, I'm going to sign a plea agreement.
All right.
May I approach, Your Honor?
Yes.
Plea and squish.
Thank you so much. question about the score sheet.
Yes, Your Honor.
I'm on page 2, and at the top it shows 10.6, and then at the bottom it shows, or the middle, it shows 14.6, but I don't see.
So I don't know why it doesn't show up, but when we generate it in the system, it adds 4 points for the technical violation.
Okay, so that's where that comes from. Just making sure.
Yes.
Thank you.
Is it for the new misdemeanor charge, so we would add the 4 points in there.
Gotcha, it just didn't, yeah, I don't know why it doesn't show up.
For some reason, it doesn't show, there's no checkbox there. I don't know why it doesn't do that.
Okay. Thank you. All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. If you'll just state your name for me one more time.
Luke Aaron Kimsey.
Thank you. In case 23 CF 1671, it's alleged that you violated your probation, and the allegation, I'm going to read it to you since you don't have counsel with you. The one allegation of violation of probation is that you had a new law offense, disorderly conduct, brawling, fighting, etc., corrupting the public moral decency, that's alleged to have occurred on May 22nd, 2025. And that, I believe, is the grounds for the misdemeanor case that we're resolving today as well, which is 25 MM 1776, in which you're charged with disorderly conduct, which is a second-degree misdemeanor. So the one allegation of violation of probation in your felony case is this new charge in 25 MM 1776. Did you read and sign the plea agreement?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
You have the right to have a contested hearing in the violation of probation case and make the state prove the allegation. You also have the right to have a trial in your misdemeanor case, which is 25 MM 1776, and make the state prove that case against you. But by entering this agreement, you're giving up your right to have that contested hearing, and you're giving up your right to have a trial. Is that what you want to do, sir?
Yes, ma'am.
All right. Is anybody forcing you to enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing on this agreement?
No, ma'am.
Are you entering the plea agreement freely and voluntarily?
Yes, ma'am.
Is there anything that I've said or the state attorney has said or that's in this agreement that you don't understand?
No, ma'am.
Do you need any more time to think about the agreement, read the agreement, consult with counsel? I'll be happy to appoint counsel for you. Anything you need?
No, ma'am.
Okay. Have you had any drugs, alcohol, medicine, any substance in the last 24 hours?
No, ma'am.
Are you suffering from any mental illness that would affect your ability to understand what you're doing?
No, ma'am.
I have a score sheet. It shows 14.6 total sentence points, and you heard me ask the state about where the extra 4 points is coming from, because I didn't see where it came from, and you heard the state's explanation. Do you understand the score sheet?
Yes, ma'am.
Do you have any questions about it?
No, ma'am.
Did you spot any errors or problems with the score sheet?
No, ma'am.
Is there any DNA on the new case, the misdemeanor? Okay. I do find a sufficient factual basis. I have both cases pulled up in front of me, and I did review them. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. Are you admitting the allegation that you violated your probation in case 23 CF 1671?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. And how do you plead to the one count of disorderly conduct, which is a second-degree misdemeanor, in case 25 MM 1776?
No contest.
I accept your plea. I find it was freely and voluntarily entered in accordance with your agreement. As to the felony case 23 CF 1671, I reviewed the file. It looks like you were previously adjudicated guilty of that underlying charge. So your probation will be revoked and terminated. You are sentenced to time served in the Okaloosa County Jail. There will be a $100 cost of prosecution added to whatever previously imposed financial obligations you already had. You will have 90 days to pay any outstanding monetary obligations after you get out before they go to a civil lien. Now, once they go to a civil lien, that'll affect your driver's license. But you do have 90 days to either pay everything or go see the clerk and get on a payment plan to keep your driver's license from being affected by these costs. And State, did I cover all of the terms and conditions on the felony case?
Yes, you did, Your Honor.
All right. Did I cover everything as far as cost on that case? Okay, thank you. As to the misdemeanor 25 MM 1776, there will be an adjudication of guilt to that one charge of disorderly conduct, a second-degree misdemeanor, and you are sentenced in accordance with this agreement to time served. There is $270 in court costs on that case. Is that correct? Okay, great. So, sir, I will put on here that you will have the same 90 days to either pay that or make arrangements with the clerk to get on a payment plan after you get out before it goes to collections. I'll write that on here. Sir, did I read out the terms of the agreement on both of your cases as you understood it?
Yes, ma'am.
Did I say anything different than what your understanding was?
Absolutely not.
Okay. You have 30 days to appeal the order of the court in both cases. And if you can't afford a lawyer and you wish to appeal, I'll appoint a lawyer for you. Good luck to you, sir.
Thank you, ma'am.
If this is the only thing that's holding you in jail, then you should get out today.
Okay.
Good luck.
Thank you, ma'am.
Thank you. All right, do I have any other private attorneys present other than Mr. Harper with RCC? All right.
Your Honor,
Yes.
Penny Bodine, it's a special situation. I was hoping we could at some point call her out of order because of exigent circumstances, but just making the court aware she's present.
Okay, I'm looking through my docket. I do see a couple of cases still remaining for private counsel. Mr. Shaw was here earlier.
He's looking for Mr. Bartley, Your Honor.
He's in the hallway.
Excellent. Okay, great. I have that one. And then I also have Mr. Dyram is here on, or supposed to be here on Mr. Joseph's. I have not seen Mr. Dyram this morning. And then I also have Mr. Crawford.
Your Honor, Mr. Crawford is here. I believe he's in the hallway.
Oh, okay, great. Well, we'll take him when he comes in. Okay. So,
And Ricky hasn't been seen in the building yet.
okay, thank you.
I know Mr. Sprouse just went to call Mr. David.
Oh, good. Thank you. While we're waiting on that defendant to be brought out, I'm going to call a few people who don't have attorneys, so maybe we can resolve that issue. Kayla Caperton. Kayla Caperton. That's 23 CF 91. Good morning. Yes, ma'am. Can you tell me your name?
My name is Kayla Caperton.
Thank you. I'm Judge Clark. And you're here on allegations that you violated your probation. We originally set the case for May 20th, but I wasn't sure you got notice, so I just reset it for today. Thank you for being here.
Oh, yes, ma'am.
Yes. So I see that you don't have an attorney. Can you afford a lawyer?
I actually did have a lawyer on the original charges. I don't know if he would stay on the case, or do I need to rehire him?
Usually, I mean, I'll defer to your lawyer on that one. Let me pull it up and take a look. But usually after the initial case is finalized, then they, that concludes their work. But I will defer to your lawyer on that one. You may want to check with them, but looks like you were represented by Mr. McGuire at that time? Okay, that's been a couple of years, I think.
Yes, ma'am.
So typically, you'd have to retain them again.
Okay.
So can you afford a lawyer, ma'am?
At this time, I cannot.
Okay. Oh, and let me see what Mr. Sprouse has to say.
Your Honor, the offer on this violation of probation is to admit the violation, pay $100 of cost of prosecution, and the outstanding monies that are owed would go to a lien, which would affect her driver's license. But I think she has options that I'm not able to advise her as far as DMV hardship licenses, but I can't advise her on that. However, that would be the resolution to get it done with today.
Okay, would you like me to appoint counsel for you?
Sure, yes, please.
Okay, I'm appointing the Office of the Public Defender's Office, and there's a form you're going to need to fill out to make sure that you qualify.
Okay.
And we've got that form here.
What is your name?
Kayla Caperton.
How do you spell that last name?
CAPDOT.
No, I didn't.
Okay.
And ma'am, if you'll just stay with us in the courtroom to fill out that form, make sure you fill out every blank, circle yes or no on every question. If it doesn't apply to you, put NA, but you need something in every blank, and then sign it. And then if we can either turn it into Ms. Farkas and she can hand it to the clerk, or hand it to a court security officer and they can hand it to the clerk. But we want to make sure it's filled out and that and have the clerk look at it, make sure you filled out all the blanks before you go, because they need that form so that we can appoint, or so that your court-appointed counsel can remain on your case.
Okay, I have a question. If I take the offer, do I need to do this?
No, you do
Okay.
not.
I'm so sorry. Then I will go ahead and take that instead of appointing counsel.
I'm sorry, you do or don't?
I do. I will go ahead and go with the offer.
Okay, do you understand that if you have financial obligations that are going to go to a lien, that could affect your driver's license?
Yes, ma'am.
And Your Honor, if I may inquire, just as a friend of the court, I don't know if Ms. Caperton was previously adjudicated guilty in the case,
Let me look.
or if she is, as of yet, not a convicted felon. If
She is
so,
not.
I would very much advise, as a friend of the court, for her not to accept the offer and to instead have the public defender's office appointed, so she does not become a convicted felon, potentially. Unless the state attorney's office can handle that with her today.
Thank you.
If she's not a convicted felon yet, I hate to see that happen.
This was adjudication withheld.
The offer will stay open if she wants to be advised by the public defender. I'm not going to revoke this offer. This offer is going to stay the same for the
Okay.
pendency of the case, so long as there's no other new law violations or anything.
Okay, so ma'am, would you like me to appoint?
Yes, please.
Okay, do. Then fill out that form and let us get that form from you and let the clerk look at it quickly to make sure it's just filled out completely.
Okay.
And let us do that before you leave, okay?
Yes, ma'am. Thank you
All
so
right,
much.
thank you. And then let's get a next court date before you go. Oh, okay.
What's your next court date? I can write it
Let's
down.
get the court date. That would be,
Obviously, she's
July.
entering a denial.
okay. This will be July 22nd at 9 o'clock. So
unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force
All
Base
right.
locations.
Based on
so
the
you have things to
stipulation
do?
between the state and the defense, the motion to withdraw the plea is granted on the condition that the defendant undergoes a court-ordered competency evaluation. And Mr. Medina will provide the order to the court that I will sign appointing the expert for the evaluation. And ma'am, I'm appointing a doctor to evaluate you. You must cooperate with scheduling that exam, and you must attend the exam once it's scheduled. Do you understand that? Okay. Mr. Medina, is there anything else I need to
I
inquire?
just wanted to be, I thought of something as I walked back to the podium, Your Honor. I intend to, because Dr. Randy McDonald has a practice in Okaloosa County and transportation will be easier for Ms. Bodine.
Okay.
I'm going to put for the order of appointment to have Dr. McDonald. As the court and the state are very well aware, there may be other issues. But I think Dr. McDonald can perhaps look at those issues at least enough to steer us if there needs to be a follow-up evaluation by what do you call it? APD. But I think it would be expeditious if we let Dr. McDonald look at her first.
I added to the stipulated order Dr. McDonald.
Okay, thank
to
you, Your Honor.
specify the expert.
Thank you, Judge.
Sure, just send me an order and I will sign it. And then does the PD's office coordinate the scheduling, or how would Miss, is it Bodine?
Bodine.
Well, we have a,
Bodine.
this is your phone number, right? That number, I don't want to say it out loud. The number I've been calling you, is
Yeah.
that your phone or is that your roommate's?
My phone.
Okay.
I just wanted,
So, Your Honor, the public defender will coordinate her meeting with Dr. McDonald.
excellent. That's what I wanted to make sure of. So ma'am, when they tell you
We'll
you
have
have
to
an
explain to
appointment,
you. There we go.
when they tell you you have an appointment to
Yes,
go to,
ma'am.
you must go.
Yes, ma'am.
Your
I
Honor,
will.
Your Honor, one other thing as an officer of the court, because based on withdrawal of the police, you will not be on probation supervision.
Correct.
But I do think the court probably intends that she would be under mental
Pretrial?
health pretrial services.
Yes, let me write
Okay,
that on here.
So you're gonna have to stay in touch with mental health pretrial services. I don't know if they have somebody at the court, but they have a phone number that we'll give you.
Okay.
And you're gonna have
I
to
don't
stay
have
in
to
touch
go
with
to,
them.
Probation.
I wrote it on here, defendant is placed back on mental health pretrial services.
Okay.
So ma'am, you'll need to contact them to check in today.
Okay.
Okay? You can do-
Right now, I just don't want her to leave without me giving her a phone number, and I'll look it up on my phone. I probably have it, Judge.
Okay.
Yeah, what's that phone number?
689-5066.
689 5066. Mental, I'm writing it out with all the words. Mental health pre-trial services, okay? So you get, it's Kelly Waschak.
Sure as I get out here, I'll call you.
Call her and let her know that you need to stay in touch with her while this, and Your Honor,
Yes.
for the record, I think I'm going to put on the other side of the page that she needs to go on an August 11 pretrial, so we have a
Yes.
date in the system.
That's exactly, thank you very much. And let me just look at the file one more time.
Yes,
see.
850, yes, ma'am. I'm sorry, I'm using a silly pen. I don't know.
Okay, I don't think an order of disposition, oh wait, an order of probation was entered already, and that would be vacated. So, don't know if I need to enter a separate order or just put it on this written order.
I would say put it on there, but
Okay.
Judge, I'm happy to prepare a more detailed order if we need to. Obviously, whatever the court says.
I'm going to
Sorry.
put on here order of probation.
The court is
Entered.
vacating your probation, so you won't be on probation right now. But that doesn't mean we know what's going to happen, okay? You've got to cooperate in your mental health evaluation and stay in touch with those people. Kelly Waschak, okay?
Okay, I wrote on the order that the order of probation entered on May 21st, 2025 is vacated. So we're back on pretrial.
Yes, Judge.
And next court date is August 11th at 9 o'clock.
Yes, ma'am.
And then
Thank you,
we're-
ma'am.
And then we're going to be submitting an order for the court to sign, and you're going to have to get evaluated by somebody else, and we'll give you that information.
Okay, thank you.
Thank you, Judge.
Thank you.
Thank you for allowing her to go now, Your Honor.
Sure. I see Mr. Crawford.
Yes, Your Honor.
Okay.
Here on behalf of Mr. Nathan Gray, and Mr. Gray is here with us all the way from Michigan. Mr. Gray, step up. And Your Honor, we have an executed sentence recommendation. It's
All right.
simple in its terms, and for the record, it's 36.2 points we don't object.
Okay, and this is 22 CF.
Sorry, walking out.
Go ahead. You're good. Thank you.
Your Honor, I'm not sure if I signed that yet.
Oh, let me take a look. No. There we go. Thank you. This is 22 CF 925. And sir, if you'll state your name for me, please.
Nathaniel Gray.
Thank you. And thank you for dressing up for court today. That's most appreciated. Yes, thank you. Thank you so much. All right, sir, if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. In case 22 CF 925, you're charged with 1 count of aggravated battery with great bodily harm, that's a second-degree felony, and 1 count of felony battery, which is a third-degree felony. Have you had a chance to talk to your lawyer about those original charges and any possible defenses?
Yes.
Did you read and sign the plea agreement?
Yes, Your Honor.
Mr. Crawford, I think I might be missing your signature too. There you go. Thank you. Thank you very much. All right, Mr. Gray, is that your signature on the next to the last page?
Yes, Your Honor.
Do you understand the rights that you give up when you enter a plea?
Yes, Your Honor.
Do you understand you're giving up the right to go to trial and make the state prove the case against you?
Yes, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Has anyone promised you anything other than what's showing on the agreement?
No, Your Honor.
Is anyone threatening you or forcing you to make you enter the plea?
No, Your Honor.
Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, Your Honor.
I have a score sheet. It shows 36.2 total sentence points. Any objections or corrections?
No, Your Honor, no objection.
All right. Is there any exculpatory DNA?
None known by the defense.
All right. I do find a sufficient factual basis based on my review of the arrest report. Sir, do you understand if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, Your Honor.
All right, and it looks like you are pleading to a lesser included offense on count 1, and that would be felony battery, which is a third-degree felony. The statute is 784.041, subparagraph 1. How do you plead to that lesser included offense of felony battery on count 1?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on count 2?
Yes, Your Honor, the state announces a null pros on count 2.
All right, and did the state discuss the agreement with the victim?
Yes, Your Honor, the state discussed the agreement with the victim.
All right, thank you. Sir, in accordance with your agreement, there will be a withhold of adjudication on count 1 on that lesser included offense. You will be placed on probation for a period of 36 months. You must successfully complete the batterer's intervention program. And on that note, Mr. Crawford, I know that you mentioned your client lives out of state. I don't know what they have in.
Neither do I. And I made a note to talk about additional terms and terms in Michigan. But when speaking with Mr. Gray, what I explained to him is what we want is for him to do what would be the Florida equivalent.
Yes.
And that he understands that.
Yeah.
And it goes along, I had a plea this morning with Judge Broderson where the individual's going back to Las Vegas. And one of the things that we were concerned about is the idea of adding additional terms or misconstruing our terms by the receiving state.
Yes.
Because he's here, I'm going to try to do my best to meet with probation with him so we can do the interstate compact together. But our belief and understanding and what we would like the judgment and sentence to reflect is the obligation is to do the Florida equivalent.
Okay, yes, and that is different than anger management.
Yes, Your Honor.
Totally different than anger management. Anger management will not satisfy this condition. So I know that when I was in a dependency division, I was aware of an online Florida certified provider, but that's been some time since I had that information. I don't know if that still exists, and I don't know if that would satisfy probation or not, but I'm sure you can explore the options with the probation officer. But it's not anger management, just so that we're clear. It's a totally different type of program. $759 to the Victim Compensation Fund. Is that correct? Plus 967?
967 is correct. I believe the other one is between us.
Yeah, that's just a
Okay.
payout from victim compensation that we're reimbursing.
Thank you. And then no contact with the victim, Taylor Sackett, with the exception of any family court order regarding custody. Did I cover all of the terms and conditions?
Yes, Your Honor, you did.
All right, and there's a monthly cost of supervision. I know what it is in Florida. I don't know what all would be involved with supervision or transfer costs if you want to transfer to another state. So whatever those costs are, you would be responsible for those as well. Sir, you need to check in with probation here. So you'll need to see the probation officer who's present in the courtroom, and she's on the front row right behind the public defender. And then you'll have to leave here and go to the Florida probation office in Fort Walton Beach, check in there, and they have to give you the green light before you can go back to your state, okay? So don't leave until you get the go-ahead from probation here, all right? And you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank
Judge,
you.
we
Yes.
just got two things.
Yes.
Sometimes the receiving states I've seen require, this is kind of the same kind of scenario of DND sometimes requiring certain words to be used when we're discussing the judgment sentence. So sometimes the receiving state wants our state to give the individual a travel permit to go back to his home state. I'm assuming the board would have no objection to a travel permit for him to go back to his home state.
As long as he checks in with probation and they're okay with it and he does what he needs to do here, I, of course, would have no objection to that. But I'm going to make sure that probation is okay as well with that
And
once
then-
he checks in.
Yes, ma'am, that's what we would do, as long as he has proof of residency and pays the money order, we'd be able to go back with the travel permit.
Wonderful.
How
And,
much is the money order?
and to the probation officer, if you could just state your name on the record so we know who was speaking.
Yes, ma'am, Jasmine Powell.
Wonderful, Officer Fowler, thank you. So, sir, I have no objection to you getting a travel permit as long as you check with probation, you go through their channels, and they say you're good to go, okay?
And then the last thing, and this is somewhat of a more esoteric kind of conversation, but in Florida, we, as the court's aware, very much aware, we have this very special thing called a withhold adjudication, where the court is not itself convicting or entering a judgment of guilt on the facts of this particular case.
Correct.
Other states, majority of states, don't actually have that particular method or vehicle of sentencing. I was explaining to my client, sometimes the receiving state, when they're going through either the interstate compact transfer or they're reviewing the record up there, they don't look at it the same way we look at it. But I want to make sure that the record's clear that this is a withhold adjudication. He is not a convicted felon by this particular plea or sentence.
That is correct. This is a withhold of adjudication of guilt. So the disposition order, or the probation order rather, will say that adjudication of guilt is withheld. So, okay.
Thank you, Your Honor.
Thank you. Good luck to you, sir. Please see Officer Fowler, who is sitting there. She has a tan-colored jacket on. And then you'll need to leave this courthouse and go straight to the probation office in Fort Walton. Okay? And then Officer Fowler will have the address if there's not a paper up there on the podium with the address.
Thank you, Your Honor.
Thank you. Mr. Flowers, I saw Mr. Flowers, and I see Mr. Shaw as well.
Judge, are you looking at, what I think you're looking at would be Jaden Bartley?
Yes.
Good morning. Mr. Bartley was present.
Okay, great, thank you. And I see Mr. Shaw present as well, and...
Yes, Judge. And we have 2020 CF 945, 21 CF 148, 21 CF 3288. I think the state has an announcement this time.
Your Honor, given the facts and some of the new law violations have been dismissed against this defendant, I know there was an amended violation filed. I am going to give the defendant the benefit of the doubt this time. The state is going to dismiss the VOP to reinstate for the defendant to complete the original terms.
Before you do that, I signed an order, let me see if it was this very morning.
I think it was on maybe Friday or.
Maybe it was, I don't remember
Late last
offhand, but I think there are new allegations.
Right. And we were aware of that, Judge, and the state was.
Okay.
Probation sent that amended affidavit to me yesterday, Your Honor.
I think I signed the warrant today, if not.
It was a situation that was past midnight. Defense counsel and I talked about it. There were some potential mitigating circumstances to that, which is why the state has made the decision it's made today. The defendant is on a suspended sentence. The state does want to remind him of that. It is a 60-month suspended sentence that is hanging over his head that the state, I will tell you, will not be as generous next time if I see him again.
Okay, it was this morning, about an hour ago, that the new warrant was e-filed.
We checked it, and I don't doubt the court, obviously, we checked yesterday because I was just back in the office Monday morning, so we checked yesterday and called the sheriff's office and everything because we had seen that the correspondence to the court had been sent in late last week.
Right.
So I'd asked the court at this time to withdraw that warrant.
I will withdraw the warrant, but I need to impress upon Mr. Bartley several things. First of all, he's out on bond on 3 VOP cases, violation of probation cases. That's really rare.
Yes, ma'am.
Second, I got the notification from the probation officer of an additional violation while he's out on bond, which is why I denied that, whatever it was, alternative sanction, and requested a warrant, and I signed it this morning, revoking his bond, putting him on no bond, because when you're on probation and you continue to have allegations of violation and you're out on bond,
Correct.
then you're lucky to be out on bond at all. So the state has very generously dismissed the VOPs. I will rescind the warrant. So it just got e-filed this morning. It's rescinded. It's rescinded. I just heard about a suspended sentence to prison. So, sir, you're on thin ice.
Yes, ma'am.
You need to take probation very, very seriously. This is a gift from the court's point of view that they've dismissed all these allegations, especially since I signed a warrant today revoking your bond and placing you in jail, which I've just recalled.
Thank you.
Yes, sir. But you better not step a toe out of line from here on out. You are facing prison. And if you come before me on a violation again, and I find that you have violated your probation, I will impose that sentence. If you score more, I'll impose the score.
Yes,
Do you understand?
Yes, ma'am.
All right. You better get to probation today and report in and do everything they tell you and follow it to the letter. And to probation, if there is any violation, I want a warrant in the future. Thank you. All right.
Thank you. Have a wonderful day.
Good luck to you, sir. You can do it, okay? You can do it.
Thank you, Your Honor. That's all I have today.
Thank you. Thank you. Yes, the order revoking bond, I think I signed a warrant today, too. I think I signed a warrant an hour ago, a VOP warrant. All the warrants on Mr. Barkley have just been vacated. Mr. Crawford, yes.
Yes, Chris Crawford again on 22 CF 925, State of Florida versus Nathan Gray. Mr. Gray is still with us. One of the things that I made a note of, but I didn't address with the court, and speaking with probation, it reminded me again to address this. Sometimes receiving states based upon the facts, not the actual plea, will then add some additional terms. I want to make sure that this is the terms that he pled to, and there's not going to be something additional that he didn't enter a plea to and didn't have a knowing conversation of what it was.
That's unusual.
It's- Yes.
Mr. Gray's probation shall be in accordance with his agreement and the standard terms and conditions of Florida probation, plus any special conditions that were in his agreement. So I would hope that the receiving state's standard terms and conditions would be comparable to ours, like
Logical.
don't violate the law,
Don't do
check
illegal
in,
drugs.
don't use drugs, don't commit any acts of violence. I mean, they're, just
Be
standard.
truthful, follow your probation officer.
Yes, all of those things. So the standard conditions may vary a little bit between states, but if they're just standard normal conditions, and then I can't vouch for what they might do in that other state as an equivalent to batterer's intervention, as long as it's not anger management. But
We'll work with them.
yeah.
We'll figure it out.
I can't imagine what other random terms they may add that wouldn't be just a standard. But his agreement is his agreement. That's what the court considers him to be in compliance with or in violation of, so.
Okay. We appreciate that. Thank you.
Sure. And I need to backtrack and put Mr. Bartley, who was here a few minutes ago, I want to put his case numbers on the record because I don't think I did. This was Mr. Shaw and Flowers' case from a few minutes ago, 2020 CF 945, 21 CF 148, and 21 CF 3288. That was Jaden Bartley from a few minutes ago. All right, and Mr. Harper?
Tavares Allen's in custody.
Okay.
He's number 18 on the docket before the court on 25 CF 386.
Okay.
He is present and approaching. He also has a new law violation, which is 25 CF 943. That is currently set for August the 11th. What I'm asking, Judge, is if we could move both this case, the violation of probation, and his new law violation to August the 13th. I was recently appointed on this case, but I did speak with him, and I think that we would like to make a counteroffer to the state, and hopefully we can resolve it in August.
Okay, any objection to setting both of Mr. Allen's cases on August 13th?
No objection, Your Honor.
Okay. So August 13th, 9 o'clock.
And I apologize, Judge, in that we were disappointed, I don't have all the discovery. My client is requesting if the state can tell me what his scores. I don't know if we have that available.
I don't have the new score sheet available with the new law yet. I haven't spoken to the victim yet, so I can't give you an offer just yet.
All right, so both cases would be August 13th at 9 o'clock. That's 25 CF 386. That's the violation of probation case. And then the new law case is 25 CF 943. Thank you, sir.
All right, sir. Thank you, Judge. The next one I have, he's out of custody. It's Condaris Jackson, 23 CF 1887. Judge, this was set for status today with the intent to sort of treat this as docket day.
Yes.
Unfortunately, I have not had any contact with Mr. Jackson. For what it's worth, there is a waiver of appearance, but I have not had any contact with him. My last efforts to reach him at the phone that we have available was not fruitful. He had court last week. I was not present, but another attorney from my office indicated that he was not present at that court hearing, although a capias was not issued.
That's probably because I must have found that there was a waiver on file.
Oh, he had misdemeanor court. I apologize.
Okay.
He had misdemeanor court last week.
Okay. So,
the only thing I will say is that notwithstanding the fact that the severity of his present charges, the offer from the state is something that is a probation offer, and based on my conversations and the history of this case and his co-defendants' cases, I believe he's inclined to accept that, but obviously he's not present at the moment.
okay. So, this case is quite old.
Yes, ma'am. And there's, if we can approach, I can give you some context if it's not reflected in the court's file.
Actually, I do have notes on
Okay.
one of the reasons.
Yes, ma'am.
I don't have all of my notes. Did the co-defendant get tried or otherwise
I
resolved?
believe the co-defendant's case has been resolved.
That was a plea, Your Honor. That was Mr. Nopes' client.
Okay, so where do we stand regarding getting Mr. Jackson's case either tried or resolved?
I think it was set today for status for plea or trial.
Is
If that's, am I correct in that?
This was a last continuance. We were likely to resolve it today. However, Mr. Jackson is not present.
Okay, so is the state ready for trial?
Your Honor, this, based on the conversations I've had with Mr. Harper, I did not send subpoenas in this case because this case was supposed to be resolved today. And if Mr. Jackson is not present, will there be a capias, or is it because there's a waiver of appearance?
Your Honor, if the court would entertain this.
Okay.
In that he's not present and I have not been able to make any contact with him. If the courts were inclined to issue a capias for his failure to appear for essentially what's docket day or jury review for him, if the court were amenable to giving him a signature bond just to sort of flag his attention, I know he's got a signature bond right now, but just to sort of like, hey, reach out to me because I have not had any contact with him.
Okay. Could the state be ready by the second week?
Yes, Your Honor.
Okay. Mr. Harper, I know it's supposed to be resolved. I don't have a lot of options, so I can either set the case for jury review in 2 days and order him to be present, but then there's no bondsman for me to notify because he's on a signature bond. Again, this is one of the reasons I don't like signature bonds, because there's no bondsman to hunt someone down when they don't show up. So, how would the state, I mean, if there's a waiver, I don't think I can enter
concern
capias
is
today.
the state is not comfortable setting the trial if the defendant is not present and if there was a plea offer that was ready to be conveyed to him so that the case can be resolved. So
What I could do is set it on pretrial, state this is the absolute last continuance. He is ordered to be present. If he fails to appear, I'll issue a capias. It'll be a no bond capias if he fails to appear on the next pretrial. Waiver or no waiver.
I
So
understand.
I could do that. That's an option.
Your Honor, and the state would request a no bond capias today, just for the record.
Okay, well, what I could do is, I'm hesitant to do that, and here's why. Mr. Harper has not been able to contact him. I don't know if he's aware of the court date today. Since there's not a bondsman, there's not somebody to independently notify him. Usually the bondsman gets notice of the court date and then notifies the defendant. And if he's got a waiver, then he's not used to coming. So I could do a capias with bond to be set at first appearance so that he would be released the next day, and that would get his attention, he'd be released with a court date. But the other option is to set it for August 11th, and then the obligation is on you, Mr. Harper, to track him down and notifying, because if he doesn't show up if I do that and then he doesn't show up on August 11th, it will be a no bond capias on that day.
The only thing I can say with respect to that, Judge, is that August 11th will allow me time to mail something, and I can try to get my private investigator to verify service, in that the phone number that we have currently is not operational.
Okay. I have an address on file, I mean, it's in the court record. I don't know if that's even still good or not. But what I will do is I'm going to set the case for August 11th, pretrial. Let me see, I don't even think he's on pretrial services. Let me just check. Because they would be checking in with him, or he'd be checking in with them also. And then,
Yeah, he had bond.
I don't see pretrial services as part of the bond. So, all right, August 11th, 9 o'clock is pretrial. Defendant is ordered to be here in person. Waiver or no waiver, he needs to be here physically in person in the courtroom. That will be the last continuance, so he either needs to resolve his case by a plea or a trial this coming up cycle. Just so that you're aware, I know you know these dates, but we would be looking at the first week next cycle to both the state and the defense, because the second week next cycle already has a lot of potential cases going. So I'm looking at the week of August 25th if this case has to be tried.
Yes.
But it sounds like it's going to be
I think
resolved.
Yes.
Ultimately, I think this will be resolved, but
Okay.
I just need to get him in here.
So, yes, well, that gives you nearly 2 months to hunt him down and make sure he shows up on August 11th. If he fails to appear on August 11th, it will be a no bond capias.
Understood, ma'am.
Okay.
And I'll make every reasonable effort to go on and get him notice of this court date.
Okay. And I'm just making some notes. All right. Anything else I need to address on Mr. Jackson?
No, Your Honor. In fact, that's all I have today.
All right, thank you, Mr.
Thank you,
Harper, very much. All right. Mr. Dyram, I have a case on the docket for Mr. Dyram. I have not seen him.
I spoke with Mr. Dyram, and he said that there's been a substitution of counsel on that case.
Oh.
I didn't ask him who it was. I don't know if it's relayed in the court or clerk record. It seems as if people get emails that things have been filed, but they can't look it up on the clerk's website.
Yeah, there's a change of system.
Yeah, I haven't, I don't see it posted yet.
But he is on the way to another county because, he was under the impression that that was filed. And he said he got a notification of it.
It looks like notice was mailed to the defendant at an address in Destin as well of today's court date.
May I approach?
Yes.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'm Wanda Ross. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Defendant on an ROR bond, and it states, the defendant shall appear in court on the recall dates listed below. It also says that a condition of the ROR bond is successful compliance with the program. Failure to comply or appear in court will result in a revocation of bond. And I do see where notice of today's court date was mailed directly to the defendant at the address that is on file with the clerk's office in Destin. It has the correct location, date, and time. One last time, Shaheem Josephs, are you present in the courtroom? The court finds that Mr. Josephs has failed to appear. The ROR bond is revoked. And I'm directing the clerk to issue a capious bond, will be set at first appearance. So it's not a no bond, it's a bond to be set at first appearance, and then they'll set a court date. And I have at least one other person on the docket that it doesn't look like they have an attorney. Calvin Johnson, are you present? Yes, sir. Come on up. Good morning, sir. Can you tell me your name?
Calvin Tyrone Johnson.
Thank you, sir. You're here on 2 cases from 2018 and also a case from 2020. Those are 2018 CF 917, 2018 CF 1249, and 20 CF 1621, it looks like. And you're here on allegations you violated your probation, and I see that you don't have an attorney. Sir, can you afford a lawyer?
No.
Would you like me to appoint one? You do not want a lawyer appointed for you? Do you understand you have the right to have a lawyer and that the court will appoint one for you if you can't afford a lawyer? Is that a yes?
Yes.
Thank you.
Your Honor,
Yes.
if I may, I had a brief discussion with Mr. Johnson. So the state is I don't know if we call it offering, but it would be to dismiss the violation of probation, then revoke and terminate because his probation actually ended yesterday. And then he would have 120 days to pay any outstanding court costs. Probation's recommendation was to waive the cost of supervision, and I believe that is it, and that would be on all 3 cases.
Oh, okay. Sir, do you wish for the state to do that, to revoke and terminate your probation and then just give you 120 days to pay your outstanding financial obligations? I saw that the allegations that you violated your probation, it was all financial.
Yes, ma'am.
So that's what the state's proposing to do. Do you want to do that?
Yes, ma'am.
Okay. Is that what the state's doing then?
Yes, Your Honor. So the state will be dismissing the violation of probation in 20 CF 1621, 2018 CF 1249, and 2018 CF 917.
All right. And is probation waiving the arrears on the cost of supervision?
Yes, ma'am.
Oh, that'll save you some money, sir. You still owe any unpaid court costs and fees, and you'll have 120 days from today to either pay them or go see the clerk to work out a payment plan.
Yes, ma'am.
If you don't do one of those things within the next 120 days, it'll affect your driver's license.
Okay.
Okay?
Yes, ma'am.
All right, probation is revoked and terminated then, or is that what the state is doing, is revoked and
Yes, Your
terminated?
Honor.
All right. Thank you, sir.
Thank
You're
you.
free to go. Good luck to you. All right, Ms. Farkas, Mr. Gates, and Mr. Medina, who would you like to call first?
Holden Jacobs, Your Honor.
Okay. Looks like that's the only case you have on the docket.
That's why I asked to call it first, Your Honor.
This is case 19, CF 2245, and we're here on allegations of violation of probation.
Yes, Your Honor. If I could have a second with Mr. Jacobs when he comes up.
Sure. All right.
We have a plea agreement to be filed in Mr. Jacobs' case, if I can get him to sign it.
Yes. Okaloosa Sheriff's Office requested $683 in reimbursement for
Yes, Your Honor.
transportation. just
That
to
is
let you know.
included in the plea agreement
Oh,
itself,
great.
1725. I have it to the U.S. prison transport. That was who I think was making the request, Your Honor.
Okay.
I can have a second to look
Sure.
at the sheet with.
Sure, thank you. Yes.
No objection to this score sheet, Mark. It appears that this will be a downward pressure.
Thank you. All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you'll tell me your name.
Holden Jacobs.
Thank you, Mr. Jacobs. You're here in case 19 CF 2245, and you're here on allegations that you violated your probation in that case. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
I can't see it.
Okay, I'll have court security bring it to you. Thank you.
Yes, ma'am.
Okay, great. Thank you.
You're welcome.
Do you understand the rights that you give up when you enter a plea?
What was that, ma'am?
Do you understand the rights that you give up
Yes, ma'am.
when you enter a plea? Do you understand that you have the right to have a contested hearing and make the state prove the allegations that you violated your probation?
Yes, ma'am.
And that by entering into this agreement, you're giving up that right?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
No, ma'am.
I do have a score sheet. It shows 98.8 total sentence points. Any objections?
No, ma'am.
No, Your Honor.
Okay. And to the state, it does appear this is a downward departure from the sentencing guidelines. Looks like the sentencing guidelines require or state that the lowest permissible prison sentence is 53.1 months.
Yes, ma'am. And he did already serve a prison time on the original sentence, and so we do agree that there's a basis for downward departure. I believe it's non-coerced.
Okay. Sir, do you understand that if you are not a citizen, this agreement could subject you to deportation?
Yes, ma'am.
Are you admitting the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. In accordance with your agreement, looks like there was a previous adjudication of guilt on the underlying charges. Your probation is revoked and terminated. You are sentenced to 11 months and 29 days in the county jail on each count, and that would be concurrent. And you, in accordance with your agreement, have waived all prior credit, including any Department of Corrections credit, but your credit starts from the date of your arrest in North Carolina on April 16th, 2025, on the outstanding warrant in this case. Is that your understanding? You're waiving your prior credit. The only credit you're going to get towards the 11 months and 29 days is starting on April 16th, 2025.
Yes, ma'am.
Okay. And it states in here that the sentence will also cover counts 10 through 13, which were consecutive probation, to counts 4 through 9. So there's no probation on any of the counts to follow. Once you serve your jail sentence, you would be just done without probation after that. Am I getting that right, Mr. Gates?
Yes, sir.
Okay. So there will be additional costs, that's in addition to whatever was imposed previously. There's a $100 cost of prosecution fee, a $150 cost of defense fee, that includes the application fee, and $683 cost of transportation. It says to U.S. Prison Transport on here, but let me just check. I thought it was the sheriff's office, but whichever it is that is requesting the reimbursement.
Yes, sir. It's requested by the sheriff's office, but the company that transported Mr. Jacobs was the U.S. Prison Transport.
Okay, well, whoever it has to go to.
Yes, sir.
Yes, it is $600, I see that, $683 that you have to reimburse for that. And you will have 24 months after you get out to pay all of your outstanding court costs and fees and financial obligations before they go to collections. Once they go to collections, that'll suspend your driver's license most likely. You understand that?
Yes, ma'am.
Okay. Did I cover everything, Mr.
Yes, sir.
Gates? All right. Sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you.
Your Honor, I have nothing further today. May we excuse? Thank you.
Have a good day.
That's all I have before the court, if I may excuse as well.
Yes. Have a good day. Thank you.
You gotta throw stuff.
Your Honor, I have a number of out-of-custody clients that I can call now.
Yes, that sounds great.
First up is Erica Cook, 23 CF 2487. She's present and approaching.
Okay.
Ms. Cook is on a VOP, here on a VOP the first time up. She'll enter a denial today, and we'd ask for the next court date.
All right. And that would be July 22nd. Is that correct? Okay. At 9 o'clock. All right.
Thank you, Your Honor.
Thank you.
Thank you. Next, I have Sheila Ann Connor, 20 CF 0056. She is also present and approaching. The state and the defense have an agreement in this case. I just need to have Ms. Connor sign it.
Okay.
And I'm providing probation with a copy.
Okay.
Your Honor, if I may approach.
Yes.
Thank you.
Thank you so much.
Your Honor, this is, as you can see, it's a fairly old case. She's scheduled to be terminated on probation July 22nd, 2025. So the way that we've written up the plea agreement is such that she can maintain the withhold of adjudication. This is the only criminal case she's ever had. So her probation won't be revoked and terminated. It'll simply terminate by expiration on July 22nd. I'm not sure if she'll have to keep checking in with probation until then. Probably. That's okay. The biggest thing will be that the restitution will be sent to a civil lien. She's paid a very, very large portion of the restitution, has paid everything asked per month and sometimes more. But probation recommended at this point that the rest be sent to a civil lien so that she can terminate probation. All monetary obligations, all other monetary obligations, any outstanding court costs to collections or a lien, whichever probation sends it. And then, of course, the public defender fee and the cost of prosecution, those additional fees, she would have 24 months to pay. But, of course, if she doesn't, then those will also go to collections.
Okay. And has the state discussed the restitution issue and the civil lien with the victim?
This is Sheila.
That is the agreement of the state. She paid $15,000 to the restitution, and we're adopting probation's recommendation.
Okay, is the victim okay with that?
I have not reached out to the victim,
Okay.
but they have been sent letters by my office, and I don't have a note from them.
Okay. Is the state comfortable proceeding with the agreement without discussing the lien issue?
Your Honor, I foresee that they would object to it going to a lien because they are currently getting paid. I can, if the defense wouldn't mind, a continuance, so I could reach out to the victim to satisfy, not that Marcy Ball has not been satisfied, because it has, but I could reach out and discuss the lien and advise them on what that means.
Okay.
Your Honor, I understand the court's concern. However, if the state has reached out to the complainant multiple times and has not heard back, and Ms. Connor has paid such a large portion of the restitution so far, I would ask that you allow her to accept the offer anyway today, given that the complainant could have responded to the state attorney at any point. But I suppose if we could have a short continuance then, not the full until July.
I think it'd be prudent if we bring her back. If Thursday would work for the state, I could reach out to the victim and have that conversation with them.
Okay, I guess what I'm trying to figure out is, have they been actually told or notified in some way that the balance, and according to the report from probation dated April 25th, the balance was in excess of $32,000. I'm just trying to figure out if the victim is aware that that is about to go to a lien.
I cannot make that representation.
Okay. All right. So, yes, I do want to reset, and I'd like for the state to, I mean, you said you sent letters. I'm just wondering, did any of the letters actually say
No,
the balance is about to go to a lien?
They do not say that.
Okay. In light of that.
Then we would be fine with coming back on Thursday.
Okay, I'm going to hand back the agreement, and I will say this. This is the most positive violation report I've ever seen from probation. Usually they're pretty bad. This is a positive report. It says things in your favor, ma'am, like you've continued to make payments. You started paying immediately towards the restitution. You've continued to make all of your payments. You've been doing the best you can. I remember when you were in court last month, I believe, and you stated, I made notes, you are trying to make it right, and that is evident. It is evident. I'm just simply trying to satisfy the court's obligation to make sure that the person is notified before I take this action. That's all. So I want to acknowledge all of the efforts that you've made to pay the restitution, and to point out that I read violation reports all the time, and I don't typically see one that's this favorable. So
Thank you.
I have an obligation under the law to make sure that that the person who is owed the money is aware that it's about to go to a lien. So, all right. So why don't we schedule the case for, ma'am, is the afternoon on Thursday better for you or the morning?
It doesn't matter.
I think our morning's sort of hectic. I'm thinking the afternoon.
I'm available anytime.
Okay. Why don't we say around 2:30?
Okay. Thank you.
Okay. So we'll reset Ms. Connor's case to 2:30 on June 19th. And then that'll give Mr. Sprouse an opportunity just to provide that notification before we take any action. Okay?
Thank you.
Thank you,
See
Your
on
Honor.
Thursday.
Thank you, ma'am. I'll see you in a couple of days.
Judge Clark?
Yes.
Ma'am, before Ms. Farkas calls her next case, I still owe you a score sheet from yesterday, and this is with Mr. Gates. I have showed it to him, so.
Thank you.
Want to leave if I may approach?
Yes, thank you so much.
So Mr. Jordan's case from yesterday, the 2 year please.
Oh, yes.
Yes, Your Honor, if it's considered reviewed, no objections.
All right, and this is case,
It's actually 3 cases now.
oh, yes, let's see. 21 CF 2345, 23 CF 1983, and 25 CF 563 from yesterday. And this is the score sheet. So Thank you, Mr. Gates, for stating you have no objection. I'm going to go ahead and sign it.
Thank you, ma'am.
Thank you. This was on the newer case. Actually,
Adjudication, 6
it was
months
a,
CC.
right. Was that a legitimate uncoerced plea bargain?
Yes, ma'am, it was.
Thank you.
I'm speaking for the defense, but yes.
Yeah, sure. It was a downward departure based upon legitimate, of course, we are.
Okay, thank you. I just wanted to check all the right boxes on the form when I sign it. Okay, this is from yesterday. And do you need this? Let's see. Page one of that plea agreement from yesterday on that case discussion. Thank you. All right, Ms. Farkas, your next
Thank
case.
you. I have just one more out of custody matter. She's not actually on the docket.
Okay.
Heather Forsythe, Forssythe. The docket number is 24 CF 2785.
Okay.
Ms. Forsythe had a pretrial conference on June 9th. She missed that court date and no bond habeas was issued. She realized her mistake and called my office the next day.
Okay.
I was out of town for Friday and Monday, and so I didn't get the message. As soon as we realized what happened, we instructed her to come to court. She's been here all morning. I would ask that, given she immediately realized her mistake and got to court as soon as possible, that we withdraw the habeas and set her for the August pretrial date.
State.
Okay.
All right. So I will recall the capias that I issued on June 9th. Yes, ma'am. And ma'am, you need to stay in touch with Ms. Farkas, okay? Let's make sure we have a good address on the court docket for you, so that way if anything gets mailed to you, we'll make sure you get it.
Has anything changed from January of '25?
I live in Valpino.
Do we have the address for
It's
it?
right there.
Oh, thanks. Okay, I'll have her fill this out before she leaves.
Yes, please turn that in, fill it out, and turn it in, give it to Ms. Farkas before you leave today. Your court date, let's write that down too, is August 11th at 9 o'clock. And as I sit here right now, Ms. Farkas, I cannot remember where we stood with that. I'll look it up. I just don't remember if we were getting ready, if this was one of those that needs to.
Your Honor, I have the offer from the state. We received the FDLE. I just need to meet with Ms. Forsythe and discuss the case. I haven't had the chance yet.
Okay, and I see that this would be the third continuance. So
yes,
I am continuing the case to August 11th at 9 for pretrial conference, but we need to, I mean, this is a third-degree felony and a first-degree misdemeanor, if what I'm seeing is correct. So the case needs to be resolved next go-around. So
yes, Your Honor.
August and September, that cycle needs to be a resolution of some sort.
Your Honor?
Yes.
I would ask that the court order the defendant to meet with her attorney before that date, because this is a January arrest.
Yes. Okay, so ma'am, I am ordering you to make an appointment to see Ms. Farkas and meet with her prior to August 11th. Don't wait until August 10th to try to get an appointment, okay? In fact, when you leave here today, Ms. Farkas, I'm
She
sure you
has
have.
my card.
Okay.
She already had my phone number, but she's.
Do you have her, is that her card in your hand? Okay. when you leave the courthouse today, because I've just recalled the capias, you were going to be going to jail. So here's the assignment for today. When you leave the courthouse, call that number, speak to somebody there to schedule an appointment to see Ms. Farkas, okay? And then go and keep that appointment. Go to see her so she can help you, because your case is going to have to be resolved in August, either a plea or a trial. I'm not aware of any other possible resolution that might be
We'll
an
see what we
option.
can drum up.
But it's plea or trial next time.
Okay.
So she's got to meet with you so she can help you, okay?
Yes, ma'am. Thank you
Thank
so
you.
much.
Thank you. Good luck to you.
Yep, Your Honor, we're starting with my in custody clients.
Okay.
First up is Lacy Cooper, 23 CF 1557.
Okay, and she is present.
I apologize, Your Honor. Lacy Cooper, this is a VOP. This is her first time up. She'll enter a denial today. We're having Ms. Cooper screened for mental health court. I believe the state attorney's on board. I've already spoken with Ms. Susan over at mental health court. So hopefully we can work this out and this case will fall off the docket. But for now, if we could request the next court date, please.
Okay, that would
Without
be,
objection.
thank you. July 22nd at 9.
Your Honor, this is Israel Chartrand, 24 CF 2293.
All right, and he is present.
He is here on a VOP. This is the first time up. Mr. Chartrand will enter a denial and request the July 22nd court date.
Any objection from the state?
No objection.
Okay, so July 22nd, 9 o'clock. That'll be the next court date. All right?
Yes, Thank ma'am. You.
Thank you.
Thank you.
Christian Clark is up next.
Okay. All right, this is case 2019 CF 2960.
Your Honor, this is Christian Clark. The state and the defense have an agreement. I just need to have Mr. Clark sign it.
All right.
And this will be a reinstatement on probation, so there's no score sheet necessary.
Okay.
Okay. All right. If I may approach.
Yes, thank you. Thank you so much.
And then I'm going to give probation a copy.
Okay.
Your Honor, there is one count in this felony VOP 2019 CF 2960.
Yes.
Mr. Clark will admit the VOP, 30 days Okaloosa County Jail with credit for time served, which he has in. Reinstate and modify probation to include a curfew from 10 p.m. to 6 a.m., which is modifiable for work purposes. His termination date on probation will remain the same. I've included the date there. I'll note that Mr. Clark was completing probation in Jacksonville, and so he'll, of course, have to be hooked up to the ankle monitor again because all the original terms, of course, just reinstating probation will remain. And then he'll be released, and of course, transferring probation to another county is much easier than to another state. His fiance has been here all morning, and I've been in contact with her for a couple weeks now, so she'll be his ride home, but just wanted to put on the record that he will be transferring to another county.
Okay. So to Officer Fowler, does he need to check in here before he leaves?
As far as our office?
Right.
Yes, so after he puts them at the jail for the GPS, he'll come to our office, or we will transfer him back.
Okay.
So the first check-in will happen here, but then after that, he gets transferred.
And then I guess once Mr. Clark gets back to Jacksonville, they might switch out the monitor or something and send that one back. I don't know. That's up to probation.
Do you know if I'll be able to get on the bracelet today and check in with you guys? Because I gotta get all the way back to Jacksonville.
I don't think so.
Okay.
So I've let Mr. Clark and his fiancée know that it might be tomorrow by the time that
Yeah.
happens, but
So by the time you get on the bus and get back up there, and then somebody has to come and attach the monitor, I doubt it'll happen today by the time you get up there. So, all right, sir, if you will please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. And just so that our record is clear, Mr. Clark and I share the same last name. We are not related. So, sir, in case 2019 CF 2960, it's alleged you violated your probation. I reviewed the case. I read the allegation. Have you had a chance to talk to your lawyer about that allegation and any ways you might have to fight the case?
Yes, ma'am.
All right. Did you read and sign the plea agreement?
Yes, ma'am.
Did you discuss it with your lawyer?
Yes, ma'am.
Is this your signature on the last page?
Yes, ma'am.
All right, thank you. Do you understand you're giving up your right to have a contested hearing and make the state prove the allegation?
Yes, ma'am.
Is anyone forcing you or threatening you to enter into this agreement?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you entering the admission freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
And sir, do you understand if you're not a U.S. citizen, this agreement could subject you to deportation?
Yes, ma'am.
Okay, thank you. All right, are you admitting to the allegation that you violated your probation?
Yes, ma'am.
All right, I accept your admission. I find it was freely and voluntarily given in accordance with your agreement. It looks like there was a previous adjudication of guilt. So I find you guilty of violating your probation based on the allegation that's in the affidavit. And you will be sentenced to 30 days in the Okaloosa County Jail with credit for time served. And your probation is reinstated and modified to include a curfew from 10 p.m. to 6 a.m. that can be modified to accommodate your work schedule. You just need to inform your probation officer and they will work with you on that if you have to work late or really early in the morning. Your probation termination date will remain the same, which appears to be January 18th, 2026, so you don't have long to go.
I know.
In addition to any other financial obligations that have been imposed previously, because of this VOP, you are assessed a $150 cost of defense fee. That includes the application fee and a $100 cost of prosecution fee. And I don't think there's any other issues or anything I need to cover, but I'm just making sure.
Your Honor, I didn't include it. I can write it or just put it on the record just to make sure that the GPS is at $1 a day.
I will write that on here.
Thank you so much.
Sure.
And I don't know if we can waive the cost of prosecution. The cost of probation.
Supervision?
Yes, if we can waive the cost of supervision, if probation is okay with that.
Like $10,000.
Thank you.
Okay, I'll write that on here, and then I'm going to hand you back the agreement so that Mr. Clark can initial it.
Thank you.
Okay? Does the waiver include any arrears probation and your lawyer? Okay, here's what I wrote on here. Well, Ms. Farkas, you can look at it and show it to your client, and if he agrees, then he can initial it. I just want to make sure that I wrote what I'm, if this is accurate.
So it says GPS at $1 a day, attached prior to release. probation agrees to waive the cost of supervision ongoing in arrearage. Okay?
Could he initial that, please?
So,
So, sir, do you have any objection to the language that I wrote on your agreement?
no, ma'am.
Okay,
Thank you.
thank you. Did I cover everything?
Yes, sir.
Okay, so sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer and you wish to appeal, I'll appoint one for you. Good luck to you, and also I want to say you have a tremendous support system. My judicial assistant has been bombarded by character references and emails. I'm not allowed to read them, but I'm aware that numerous people have written letters on your behalf, and you're very fortunate to have such a wonderful.
People that cared about me.
You have I don't think I've ever gotten that many letters. I'm not supposed to get them at all, but they don't know that. But I'm not allowed to read them, but I'm aware of it. And sir, you have a lot of people who are supporting you. So
Thank you.
good luck to you.
Thank you.
Your Honor, next up is Shane Duggar, 23 CF 1321.
Okay.
This is a VOP. This is the first time up. Excuse me.
Okay.
Mr. Duggar will enter a denial today and will request the July 22nd court date so I can discuss with him the state's offer.
Okay.
Without objection.
Thank you. So July 22nd at 9 o'clock will be our next court date.
Carl Edwards is up next.
Your Honor, next up is Carl Edwards, 2010 CF 871. I believe at the last court date, I let the court know that I had just received medical records for Mr. Edwards. I just haven't had time to discuss them with the state attorney yet, so I apologize for the delay. They're kind of numerous. So if we could have one, I think I'm comfortable saying last continuance for the July date so that I can discuss those records with Ms. Basso.
Okay. Any objection?
No objection, ma'am, and Ms. Farkas, if we can get to that sooner, then we can always move it up.
Perfect.
Okay. So July 22nd at 9 o'clock will be the next court date, and we'll see you then.
Thank you so much.
Thank you.
Judge Clark, Mr. Edwards is my last case, may I excuse you?
Yes. Have a great day.
Your Honor, next up is Kyle Eli, 23 CF 864.
All right.
The state and the defense have reached an agreement in this case. I just need to have Mr. Eli sign it.
All right.
This plea agreement will also include, he has a misdemeanor. That case number is 25 MM 1539. That is the sole basis for the violation of probation.
Yes.
Sorry, Your Honor, I just want to double check the score sheet.
Okay.
I apologize. Okay.
Just bear with me
Yes,
one
sorry.
second. All right.
Okay, I apologize, Your Honor.
No
I was
problem.
just double checking the score sheet.
No problem, thank you. Thank you.
Your Honor, the wording here, similarly to one that we addressed earlier, is meant to maintain Mr. Eli's withhold of adjudication. He is not a convicted felon. There was a previous withhold in the 23 CF 864. So the way that we work it out with probation is that the probation is reinstated and modified to include a special term of 120 days Okaloosa County Jail, and then probation will automatically terminate upon his release from the jail. So I'm providing this copy to probation. And this will run concurrent with the count in the misdemeanor case.
Okay. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Kyle Ely.
Thank you. In case 23 CF 846, it's alleged that you violated your probation. And in case 25 MM 1549, you are charged with 1 count of petty theft, which is a first-degree misdemeanor. Have you had a chance to talk to your lawyer about the allegation that you violated your probation and the charge of petty theft?
Yes,
Your Honor, I mistyped just in the first section, it's 1539. It's correct in the other places on the plea agreement, but the misdemeanor docket number ends in 1539.
Thank you. Did I say 154?
Yes, because I
Okay.
typed 1549.
That's fine. It's the misdemeanor that is the subject of this particular hearing that Mr., is it
Ely, yes, ma'am.
Ely?
Yes, ma'am.
Ely is charged with is 25 MM 1539, and it's petty theft. So, sir, did you have a chance to talk to your lawyer about that new charge of petty theft?
Yes, ma'am.
All right.
Your Honor, I'm sorry, the state attorney just informed me of something, if I could briefly relay
Sure.
that to him. Your Honor, there's a restitution amount in the misdemeanor that the state attorney is requesting, and informed me that they could send it to a civil lien, but Mr. Ely would prefer to pay the restitution amount.
Okay.
$574.81.
Okay.
And if that would be included, of course, in the 24 months to pay all those costs.
Who is it owed to?
It is to Flyby, which is FLYBUY. The address is 4651 Highway 20 East, Niceville. What the state would ask for, and forgive the state for oversight, is if he could be on probation to pay that, and then it would automatically terminate as soon as he pays the costs.
Sounds like y'all.
That
need
is a
to talk
completely
some
different
more.
plea agreement than we talked about. I
Okay.
can't have my client enter a plea to that
Okay.
without talking to him.
What I'm going to do is, I went ahead and wrote on here about the restitution. You can white it out if if y'all need to start over. I don't know what you're going to do, but there you go. Here's the score sheet too. I think I already signed it, but I can,
I don't think that the score sheet would change.
well, I filled in.
So I'll just speak with him in the back, and then
That's
hopefully
fine.
you can break him back out.
That's fine. Okay, we'll recall Mr. Ely's case.
Thank you.
Okay.
Robert Eskold has a VOP 25 CF 322, and then a new loss 25 CF 1043.
Okay. And he is present?
Yes.
Okay.
Your Honor, the state, if you recall, we had a bond hearing on this that was relatively lengthy about the defendant having immunity by statute for medical assistance.
Yes, I do remember that.
It's about a 45-minute long argument between myself and Mr. Medina.
I remember that.
The state did research. That statute does apply to Mr. Escol for the new law violation. The reason it applies is because, well, it did not apply at the bond hearing because he was charged with trafficking in a controlled substance, which takes it out of that statute. However, as Your Honor saw, the amount that was sent to FDLE was like right at the trafficking amount.
I think it said approximately, if I'm not mistaken.
Yes, which
Okay.
is not beyond a reasonable doubt. So it came back from FDLE and it is not a trafficking amount. And there's also not any evidence of specific intent to deliver, sell, or manufacture any drugs. Given that statute that we argued about, he is completely immune from prosecution given those facts and the evidence that was obtained through his seeking of medical assistance. So we dismissed the new law violation yesterday for those reasons that I mentioned. And the new law violation was the only violation on the violation of probation. So that will be dismissed as well.
Thank you very much, Mr. Sprouse. So, is this the only thing holding
Yes,
you
Your
in
Honor.
jail, sir?
Yes, ma'am. Yes, Your
Then
Honor.
the state has just announced a dismissal. They dismissed the new case yesterday. Since that was the basis for your violation of probation, they've dismissed that as well. So.
So
you
I
should-
just get out and check into probation?
Yes,
Yep.
you're still on probation.
Okay.
He's on it.
Okay.
So, you're still on probation, so you should get out today. I don't know what time you'll get back up to the jail and get out processed, but you should get out today unless there's something else holding you that I'm not aware of.
Yeah.
So,
And his girlfriend has also been here all day, has been very involved in his case, and so she knows as well that he needs to go to probation. He'll just be put back on probation like before.
yeah, so if you don't get out in time to get there today, because I don't know what time the bus is going to get back to the jail when you get out processed. If you get out in time to make it to probation today, you need to go today. If you don't, you need to be there before 9:00 a.m. tomorrow, okay?
Yes, Your Honor. And it's 4 or 5 o'clock today? Is it-
If you, let me ask.
I'll call if I.
Okay,
yeah.
let me ask Officer Powell, what time, like if he gets out at what time would be the cutoff for him to come today?
If you could make it by 4 p.m.
4 p.m.? Okay.
Yeah, but if you don't get out in time, just be there before 9:00. I'd call them whenever
ma'am.
you get out and just say, hey, I got out at, 4:30 or whatever, I can't make it there. Be there before 9 tomorrow, okay?
Thank you so much, Your Honor.
Good luck to you, sir.
Thank you.
Thank you.
Aaron Becky is up.
Was it announced for legal terms?
Yes, reimpose, he's just,
Yes, so all the original conditions.
yeah.
Your Honor, this is Aaron Feckety, 23 CF 2817. The state and the defense have reached an agreement in this case. I just need to have Mr. Feckety sign it.
Okay. And Ms. Farkas, I think do you only have one more after this?
I believe so.
Okay. Oh, I see another one. Oh, no, I take that back. There's another one that needs to be
I
recalled.
apologize.
No.
I'll be quick though. If I may approach.
Yes, thank you. Thank you so much.
Yes.
Your Honor, there are 5 counts here. They're all concurrent. Really only count 1 needs to be read out because everything else is
The same?
exactly the same.
Okay, all right. Thank you. All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Aaron J. Feckety.
Thank you. You're here in case 23 CF2817, and you're here on allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am.
Yes, Ms. Farkas. Yes. Did you have a chance to talk to your lawyer about this agreement?
Yes, ma'am.
Do you understand the rights that you give up when you enter into an agreement?
I do.
Do you understand you have the right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am.
You understand you're giving up that right?
Mm-hmm.
Yes, okay. Are you entering the plea freely and voluntarily?
Yes.
Has anyone promised you anything other than what's showing on the agreement?
No.
Has anyone forced you or threatened you to enter into this agreement?
No.
Are you satisfied with the services of your lawyer?
Super satisfied.
That's great to hear. Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
Nope, not for the last 18 months.
Good for you. Congratulations on that. That's not easy. I do have a score sheet. It shows 47 total sentence points. Any objections or corrections?
No, Your Honor.
Okay, it does show 14.25 months is the lowest permissible sentence.
Your Honor.
Okay. And, sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Oh, I understand.
Okay, thank you. Are you admitting the allegations that you violated your probation?
Yes.
I accept your admission. I find it was freely and voluntarily given. And in accordance with your agreement, it looks like there was a previous adjudication of guilt on all of the felony counts.
Yes, there was, Your Honor.
Okay. So on each count, there will be a sentence of 14.25 months Department of Corrections with credit for all time served. That's going to be concurrent on all counts. Probation is revoked and terminated on all counts. And, sir, you will receive credit for the time you completed at Phoenix House. It says on here 286 days at Phoenix House.
Yes, I confirmed that with probation. It was 9 months and 13 days that he completed at Phoenix House, and the state has graciously agreed to give him credit for that time.
Okay. And the state, it says on here, the state stipulates that all time has been served and that the defendant is eligible for immediate release.
This is to prevent a situation we've had in the past where someone gets transported all the way down the road to DOC
And then,
and then is either dumped out there or brought a little way back. So
Okay.
he's done all the time.
The defendant did 169 days in Okaloosa County Jail. Then he went to Phoenix House for a total of 286 days, and then he's been incarcerated for 82 days. That comes out to 537 days, and that's greater than
his prison score.
exactly.
Yes, okay. All right, so let's see. Probation is revoked and terminated on all counts. That sentence to the DOC with all that credit is concurrent and imposed on all counts. And the stipulation that Mr. Feckety has already served his time, he has more credit than the time that's imposed, would apply to all counts. And then, sir, there are additional financial obligations that are imposed. That would be $150 cost of defense. That includes the application fee, $100 cost of prosecution. You have 24 months to pay all of your outstanding fees, fines, or court costs after you are released. After that time, they're going to go to collections, and that'll affect your driver's license. So did I cover everything, Ms. Farkas?
I was just explaining to Mr. Feckety that yes, it's $250 today, but then any court costs, if he had the $615 in court costs in the case that had previously been imposed, then that still
All of
applies, and he has the 24 months to pay all those costs. But If he doesn't, then all of that will go to collections.
Yes. Now, the clerk's office will work with you to come up with a payment plan. So if you get on the payment plan, and as long as you're making your payments and stick to the plan, then they're not going to send you to collections. They would, if you miss a payment, they would, but as long as you know,
Yeah. I
stay on
think
your
that's
plan.
the same kind of payment plan I'm on with Santa Rosa.
Maybe so. Yeah, but they have that here too, so that might help you. But good luck to you, sir. Thank you.
Awesome, thank you.
You have 30 days to appeal the judgment sentence of the court if you can't afford a lawyer, point one.
No, there's no, okay. Judge, this is Quincy Powell.
Okay. 24 CF 687.
Your Honor, Quincy Fowler, the state and the defense have reached an agreement in this case. I just need to have Mr. Fowler sign it.
Okay.
And it's a misdemeanor VOP, so there's no score sheet required. Sign right there.
Thank
Sorry.
you. Thank you.
No problem. This is Quincy Fowler, 24 CF 687. The state and the defense have reached an agreement, if I may approach.
Yes. Sure. Thank you, sir. If you will raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes, ma'am, I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Quincy Powell.
Thank you, sir. In 24 CF 687, there is an allegation that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation and any possible defenses?
Yes, ma'am.
All right, and actually it's two, I think two allegations, actually. Have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am, I do.
All right. Is anybody forcing you or threatening you to make you enter the agreement?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right. Are you admitting the two allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, your probation is going to be revoked and terminated, and you are sentenced to 60, that's 60 days in the Okaloosa County Jail with credit for time served. And you, looks like we're already adjudicated on the underlying offenses. In addition to any previously imposed financial obligations, the court is imposing the mandatory $150 cost of defense fee. That includes the application fee, and a $100 cost of prosecution fee. And you'll have 24 months after you get out of jail to pay all of your financial obligations in this case. After that, if they're not paid, they'll go to collections. That would affect your driver's license.
Okay.
So good luck to you, sir. You have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one. Thank you.
Right this way, sir.
I'm going to give a copy to Mr. Fowler as well. Good luck, Mr. Fowler. I think my last one is Kyle Huey, that I just need to go back and speak with them.
I actually had a few more. Let me just check. Don't you have a couple?
She'll look aside from
Okay.
the one she.
Let's see. I have Gabriel Dorado.
Oh, yes. So I spoke with Ms. Basso. Gabriel Dorado is my client who lives in North Carolina and will be submitting a written plea agreement to the misdemeanors. Because of the delay with the filing, Ms. Basso was able to file the amended information yesterday.
Okay.
So we couldn't have submitted the written plea agreement. So if we could, I'm sorry to ask for the continuance, but I just, need to have him submit the written plea agreement now.
Okay, so when do you want to set this for a status on the written plea? Do you want
Maybe the July
22nd?
Yes, thank you.
Okay, July 22nd. Now, if he doesn't, I understand there have been problems with the portal, but
now we should be able to.
Now it should be resolved. He either needs to enter the plea and return it, or show up here and let's try the case.
Yes.
So I need either a filed written plea agreement or Mr. Dorado's person in the courtroom on
Absolutely,
July
Your Honor.
22nd at 9, so we can resolve the case. Okay.
Agreed.
Thank you.
Thank you.
Who's waiting for you?
Okay, great. I'll go.
And Mr. Medina, whenever you're ready, we can start on some of yours. While Ms. Farkas goes, and actually, we're going to take a 10-minute recess. And then we're going to come back and start on Mr. Medina's cases. And then we're going to, if it's okay with everybody, we only have a handful more cases. We will take a later lunch break rather than break for lunch and then have to come back just for a few more cases. That way the bus can get back to the jail and the people who are supposed to get out today have a greater chance of getting out today.
Yes, Your Honor.
So
That's fine. I think most of mine and Mr. Medina's cases too are pleas, almost most of them, I think.
Yes, or brief, continuances.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.